Hello, Doctor and my friend. We are from Group 5. This is our video presentation on business law assignment. I'm Lilin. My group mates are Shahira, Labitsin, and Mirza. Before we go into details on our question, I would like to talk about some software that we use to prepare the assignment. Firstly, we use PowerPoint for the presentation slide because it has the flexibility to let us create our own design for free. It also has a lot of cool and easy to use software for us to explore. Next is CapCut Video Editor. For video editing, we choose this software because despite being a free software, it doesn't have watermarks, and it is easy to use and the exporting video function was very fast. Lastly, we use the Google Apps, especially on Google Meet and Google Doc for group meetings and compile our essay. Now onto the question. The question states that Faizal Tahir has entered into a contract with UMT Cultural Club to perform in a solo concert that will be held at the State Stadium. In return, Faizal Tahir will get 5,000 in advance and the remaining 5,000 after the event. However, the concert was cancelled due to heavy rain and storm. The club decided to reclaim the 5,000 they had given to Faizal Tahir, and Faizal Tahir sued the club for the remaining balance. From that, the issue we encountered was the Faizal Tahir and UMT Cultural Club in that specific breach of contract can be discharged under the category of discharge by frustration. Under Section 2H of the Contract Act 1950, a contract is an agreement enforced by law. Faizal Tahir had accepted the offer made by UMT Cultural Club to perform in a solo concert. In return, Faizal Tahir get 10,000 paid by the club. Therefore, a contract between both parties has appeared. When either one party of the contract fails to perform his or her obligation or breaks the agreement as set out in the contract, it is considered as breach of contract. It seems that both parties had breached the contract whereby Faizal Tahir did not perform in the solo concert and UMT Cultural Club did not pay Faizal Tahir the remaining 5,000. Contract Act 1950 also stated that under Section 57, if there is an impossibility act to its obligation after the contract has been created, by the occurrence of some unavoidable events, the contract can be discharged of frustration. Next, I will pass it to Mirza on legal principle.
Legal principle concepts of frustration. Frustration occurs whenever a contract, after its information, becomes impossible to perform without the default of either party. The doctrine is often called subsequent or supervening impossibility, and its effect is that the parties are released from their contractual obligations. If the lessee convenient to repair a house, though it is burned by lightning or thrown down by enemies, yet it ought to repair it. Definition of discharge by frustration. Section 57(2) of the Contract Act 1950 provides for the doctrine of frustration, a contract to do an act which, after the contract is made, becomes impossible or because of some event which the promisor could not prevent. Unlawful becomes void when the act becomes impossible or unlawful. The section envisages two main instances of frustration, namely the impossibility of performance and unlawful to perform. The parties exempted from performing their future obligations under the frustrated contract must achieve their agreements that arose before the frustrating event so that there is no frustration between the two parties. In Section 60C, any person who has received any advantage under the agreement which is discovered to be void is bound to restore it or to make compensation for it to the person from whom who received it.
Next part is argument. First, argument for Faizal Tahir. Based on the situation, Faizal Tahir could not perform the obligations of the contract, which is performing a solo concert due to heavy rain and storm. However, he already planned his time and put in effort for the concert. So he felt entitled for the payments of Rm 5,000 ringgit that was paid in advance and another Rm 5,000 that was promised after the concert to compensate for his time and effort that he has put in. He also argued that the concert is cancelled not because of him, so he felt that the payment, which is Rm 10,000, belongs to him. However, UMT Cultural Club argued that the contract was clearly agreed for Faizal Tahir to perform in a solo concert, but due to the unexpected event, which was the heavy rain and storm, the concert was cancelled and Faizal Tahir did not get to perform at the concert. The club did not get any benefit from Faizal Tahir, so it was irrelevant for them to pay him. The club also argued that they were also a victim from the contract, so they have the right to claim back the payment that they have paid to Faizal Tahir and not to pay him the remaining Rm 5,000 ringgit.
The discharge by frustration in Section 57 has stated that if there is an impossibility of performance after the contract has been made by the occurrence of some event which radically change the circumstances contemplated by the party, the contract is discharged. Therefore, to identify whether the case that happened between Faizal Tahir and UNT Cultural Club can be discharged by frustration, we can relate our case to the supporting case, which are Taylor Sue Cowell and Craig Sue Henry, because both are under the category of discharge by fluctuation. Firstly, the fundamental case in the area of fluctuation related to contract law was the case of Taylor Sue Cowell. The case involved a music hall where the defendant agreed to let the plaintiff use it for 4 sessions days. However, the music hall was accidentally burned down before the first concerns, resulting in the concerns could not be held on time. The plaintiff seek to bring an action for the defendant breach of contract for failing to provide the hall and wanted to claim compensation for damage incurred. In this situation, the claimant action for breach of contract failed, as the failure means the contract was impossible to perform, therefore fell under discharge by fluctuation. Related to the Taylor Sue Cowell case to Faza Hill Sue UNT Culture Class case, the similarity between both cases when a consequence of an unavoidable accident has become impossible for both party agreement to carry out. The case has been frustrated. Furthermore, in the case of Craig Sue Henry, the plaintiff and the defendant enter a contract for the defendant to rent a flat with £25 deposit to build the coronation of the king. However, due to the king becoming ill, the coronation never took place. The plaintiff sued the defendant for the remaining £50 due under the contract, since the defendant refused to pay. In this situation, the defendant is excused for paying the remaining balance because his purpose for entering the contract as the foundation of the contract was understood by both parties, which is to witness the coronation of the king, and the coronation was cancelled. Therefore, the case was frustrated. Referring Craig Sue Henry case to our case, UNT Culture Class purpose is to get Faza Tahir to perform in the solo concerts. Unfortunately, the concert was cancelled due to heavy rain and storm. The purpose of the contract has been frustrated. UNT Culture Class could not get any benefit from Faza Tahir. Therefore, UNT Culture Class is dismissed for paying the remaining balance. According to the information from supporting case, if the contract was discharged by fluctuation, the contract between Faza Tahir and UNT Culture Class will be void, and UNT Culture Class shall be excused. If Faza Tahir sue UNT Culture Class for the balance of 5,000 ringgit, it will not be successful. The consequence of fluctuation terminates the contract automatically. The parties are discharged from further obligation. The contract is void. With that, Faza Tahir cannot claim the balance of 5,000 ringgit. Finally, Section 66 stated that any person who has received any advantage under the agreement, which is declarable to be void, is bound to restore it or to make compensation for it to the person from whom he received it. Therefore, the payment received by Faza Tahir need to return to UNT Culture Club, and he cannot claim the remaining 5,000 ringgit that was promised by the club to be given after he performed the concert.
In conclusion, after referring to above research, we can identify the case between Faza Tahir and UMT Cultural Club is discharged by frustration due to heavy rain and storm. Faza Tahir need to return the 5,000 that he received in advance to UMT Cultural Club. And that's all from our group. Thank you.